Good morning, good morning, good morning. Good morning. For those that don't know me, my name is Taryn Hillsman. I'm the state conservationist for USDA NRCS, Natural Resources Conservation Service, for those not familiar with our agency under the United States Department of Agriculture. And it's very good to be here this morning, sharing the stage with Sarah here to talk about this very important topic. As I've learned more about ALEI's work, I've come to learn that there's a lot of great topics, a lot of important work that the initiative is doing, and we're just happy as an agency to have a small part or role in this conference today. So thanks again for having me here. I want to talk a little bit about soil health and why. I know some people are probably curious as to, soil health and leases, how does that really go together? And I guess I was kind of curious myself when Sarah and I first started talking about it, but as she was educating me more on the issue, and as we've known some of the stumbling blocks that we've had with agencies in terms of working with producers who do not have leases or do not have formal arrangements by which they use the land to produce their crops and all these kinds of things, it did become more clear why this is such a salient issue. So for those of you that don't know about our agency, NRCS has been around for a very long time. We started out as the Soil Erosion Service. So we've been around for about 80 years or more as the federal agency responsible for private lands conservation across the United States. Most of you know that we came out of the Dust Bowl era, and scenes like this were all too common back in the 1920s and 30s in terms of the Dust Bowl. And I will put in a plug for a film that our agency has just released on Hugh Hammond Bennett, who is the father of soil conservation and the father of the soil conservation or soil erosion service, which became Soil Conservation Service and now today's NRCS. So if anybody's interested in that, let me know, and I can definitely get you the link to the movie. And I think it's very interesting, and it'll give you a lot of information about that time period and how we came to be. So at the heart of what we do is soil conservation planning. And it's not just NRCS or a federal effort, as many of you know. In Maryland has a proud history of NRCS as a federal agency partnering with local partners, what I call are often referred to as our core partners, core conservation partners, which include the soil conservation districts in each of the counties across the state of Maryland, and then also our Maryland Department of Agriculture, who all three of us have employees in each of our field office service centers in every county across the state that go out and do just what you see on this slide. We have planners and professionals that go out and work hand in hand, one-on-one with each farmer across the state to develop plans that address natural resource concerns on their farms. As a part of that planning effort, one of the resource concerns that we focus on quite heavily and we really have a renewed interest in is soil health. That's something that I think back in the 20s and the 30s, as you can see, obviously with the wind and soil erosion issues that came out of the Dust Bowl, sometimes I think we got so focused as an agency on the erosion aspects of that we really didn't focus in a lot on the nutrient aspects and the soil health aspects of what we do as an agency. And so we've refocused quite a bit in the last, I'd say, 3 to 4, maybe 5 years on soil health and how important it is in trying to educate communities and educate producers about ways that they can take measures to improve soil health on their farms. And this is just one of the tools that you see here on the slide that our planners and professionals use, which is called a soil health card. It doesn't require you to go to a laboratory. You don't have to take any kind of tests or anything like that. Most of them are visual indicators that a professional working in concert with the producer can come to a determination about the health of the soil on their farms, about organic matter, all these kinds of things that are so important to soil health. So these are some of the practices, or most common practices. Certainly this is not an exhaustive list, but these are a lot of the common practices that we work with producers and we recommend in their conservation plan that will, in fact, improve soil health. And so you can see a lot of them listed there: conservation crop rotation, cover crops, which everybody knows is so important here in Maryland. Maryland has a huge cover crop program, unlike any in the nation that I'm aware of. And so producers are, and producers do a very good job with this. Let me just be clear about that. No-till, which is another one of the practices that we recommend, has been overwhelmingly adopted by producers across the state in terms of their cropland. So producers do a very good job with it, but it's something that we can always improve upon, and it's something that we're always working with them to try to improve upon. And these are just some more of the practices and some descriptions of those practices that we'll sometimes often recommend. For those of you that are not very familiar with, you say, well, soil health, all soil looks the same, or some people even refer to it as dirt, which is kind of like a bad word with us in our agency. We get a little bit sensitive about that when we hear the word dirt. But certainly soil is very, very important. This is from a farm in Charles County, which is in southern Maryland. And you can look at the soil itself, and you can see that it's grinded up. You don't see a lot of life there. You don't see a lot of organic matter, and you also see the absence of worms, microbes, all those kinds of things that are in the soil that are so important, that gives vitality to the plants that are grown in the soil. So, one of the things that I say to people oftentimes that don't sometimes get the connection, and believe it or not, people sometimes don't get the connection between healthy food and healthy soil. Well, the soil's got to be healthy if the foods are going to take the nutrients and the minerals and the things that it needs. And it would be a shame to be eating a lot of spinach and things that you don't necessarily eat enough of and not be getting the full value of all the minerals and the nutrients. But that's what we're up against in a lot of ways, and I don't want to make it more excessive than it really is, but we certainly want to make sure that the soils are healthy. You can contrast that with another field that was not too far away in Charles County, and this was a farm that actually had been doing no-till for a number of years and had been doing some of the other practices that I showed you on previous slides. And you can see the difference in the health in the soils. You see the root systems funneling down from the surface of the soils down into the soil, making way for aeration. You see a lot more of the beneficial kinds of things that you want to see in the soils. So we often try to use these differences to encourage farmers to adopt these practices. So you say, what does all this have to do with soil health on leased land? Well, leased land now in the state of Maryland represents about 40% of the farm production across the whole state. And that's not an anomaly in Maryland. I mean, I think that's really close to the average nationally in terms of how much farmers are now relying upon leases as a vehicle for having more farmland in production. You see, it's a trend that's been going on for a number of years. Farmers are less likely to buy more land for farming, and it becomes more economically viable to lease that land. And so when you think about it, for us as NRCS, we will work with the landowner, or we'll work with the tenant, or we'll work with the producer in terms of technical assistance that they can receive, and also the financial assistance programs that also incentivize farmers to implement some of these practices. The fact of the matter is that in most cases, and I think most of our partners will agree, that a lot of these practices they're very expensive to put in on the ground. And even when producers are getting the financial assistance that they get, they still have to come out of their pocket anywhere from as low as maybe 15% to as high as 50 or maybe 55% of the cost of that practice. So you can see why on land that you do not own, that becomes somewhat prohibitive in terms of making that investment. And so when we're working with producers trying to find ways to help them to implement more of these kinds of practices, that's one of the barriers that we run up against. Another one is that when the health of a soil gets as bad as, or maybe worse than the picture that I showed you from Charles County, repairing that soil or improving the health of that soil doesn't just happen overnight. It doesn't just happen in a year. It can take sometimes 3 to 5 to upwards of 7 years of good soil health practices to improve the health of that soil in a meaningful way. So it is an investment, and it does take time. And if you don't have, and a lot of producers have a year-to-year kind of a handshake agreement, or maybe some kind of a lease that's more of a short term, you don't have the certainty oftentimes as the producer or the person that's producing the crop to go out there and make that kind of investment, because you're not sure that you're going to have that land for a long time. So these are just some of the things that I wanted to highlight, and I'll let those things lead into Sarah's presentation on, she can get a lot more in depth on it, but thank you for your time.
Okay, good morning, everybody. I'm wearing a couple different hats today, but right now I'm here to tell you about some legal resources for improving soil health. And like Taryn referenced, you might not necessarily think of legal issues and soil health together, but we need to create some solutions to overcome some of those challenges that he highlighted. So just a few statistics, like he mentioned, about 42% of our acres in Maryland are leased. And although we have phenomenal performance by our farmers in Maryland in our cover crop program and in conservation tillage, we actually have quite low participation in federal conservation programs on leased land and our Maryland Agricultural Water Quality Cost Share, or MAQS. So it's a problem. It's something we hear anecdotally quite a bit. When I'm across the state talking to farmers, I hear them say, yeah, I have these practices on my home farm, but I don't have that on my leased acres. And so my colleagues and I at ALEI have been trying to talk to folks for years now and figure out why not. What's the stumbling blocks, what's the problems, and how can we help you get over that? Because 42% of our acres in Maryland, that's too much to let that problem go unaddressed. Why is it important for farmers? It's important for farmers because it provides them economic benefits to have these types of conservation practices on their farms. It's going to decrease input costs. It's going to allow them the opportunity to participate in those government cost share programs, like was mentioned, and it's going to give them the opportunity to market to more sustainably minded customers. Clearly, it's important from an environmental perspective. We all know we're entering the phase 3 of our Chesapeake Bay WIP. We need now more than ever improved soil health, improved water quality, and less soil erosion. Ultimately, all of those things are also going to increase the value of the land. So a difficult part of this problem is you have two parties involved. You have a landowner who may or may not be an involved landowner. Many of them are absentee landowners. And then you have a farmer. Very different values, very different interests at heart there. But when you start talking to a landowner and explaining to them how this is going to increase the value of their property for future generations, that starts to get them interested. So the challenges, as was explained, first, communication breakdowns. This is probably our #1 challenge. When I talk to farmers who lease a lot of acres, they say, I maybe talk to that landowner once a year, or I see them during hunting season, or maybe I talk to them a couple times a year, but they don't know anything about farming, or they don't know anything about NRCS. They don't know anything about conservation practices. Maybe they know a little, maybe they know a little bit enough to get in trouble, and maybe it's just a difficult conversation for a farmer and a landowner to have. So getting over those communication breakdowns is a big part of addressing this problem. Lack of a written lease is also a big problem. As Taryn mentioned, to be able to qualify for some of these programs, you have to indicate that you have a lease. A lot of folks simply don't have a written lease. All of us at ALEI, we're lawyers, we love leases. We love paper, we love people to sign on the dotted line. We can't help but they mind warped us in law school to love leases. I know not everybody loves a lease, and so getting over that mental stumbling block that a lease isn't a bad thing is a big, big challenge. A lot of these leasing relationships are an indefinite term. They're a year-to-year situation. As Taryn mentioned, these conservation practices take years to implement, and so if you have an indefinite or a short-term lease, those two things just don't match up. And finally, financial uncertainties surrounding conservation practices. These things take money to implement, it takes some time, and if you don't have a lease that allocates that, it's probably not going to happen. And then finally, risk aversion. When you're talking about a conservation practice, you may be talking about taking land out of production, and that puts everybody at risk. That puts the profitability of the farm at risk. So legal challenges. Oral leases present a lot of legal challenges, and we all spend a good part of our time at ALEI educating folks across the state about this. I would encourage all of you to also educate folks and to point them towards our leasing resources. We have a wonderful leasing workbook that my colleague Paul had put together. But a handshake lease leaves both parties at risk, and that's really what I try to tell folks, is that you're at risk of faded memories, and that's going to put you at risk for a misunderstanding, which may end up in a costly legal battle, which nobody wants to do. And finally, there's a lot of legal gray areas when it comes to leasing. We have very little lease law in Maryland. I think a lot of people are confused by that. They think their oral situation is going to be fine because we'll get to court and the judge will believe me, sort of thing. But we don't have very much leasing law to actually protect either party in one of these arrangements. We have no implied covenant of good husbandry in Maryland. Now, what is that? That's a bunch of legal mumbo jumbo. Basically, what it means is we don't have an implied obligation on the part of the farmer to be a good farmer. What is a good farmer? What does that mean? If you end up in court, it's going to be a very gray area. The judge is going to have to decide if, for example, we have a lot of folks in Maryland that practice no-till. We've all kind of accepted that as the norm. If you lease your land to a farmer and there's nothing about tillage in your lease and that farmer starts tilling the heck out of your field, is that bad farming? Is that a violation of a lease? I don't know. And that's the kind of misunderstanding that can easily be resolved. So what are the solutions? Well, we're hoping that we can try to bring folks to some resolution on this. In collaboration with the Harry Hughes Center for Agroecology, we are creating an agricultural conservation leasing guide, and it's going to help landowners and tenants try to overcome some of these challenges. It's going to have leasing strategies that folks can use, and importantly, it's going to have communication tools. So even if folks are still opposed to that written lease and signing on the dotted line, and I get it, there's a lot of stuff that goes along with that, I would still encourage you to tell folks about this resource because it's going to give them the communications tools they need to talk to each other, and that's the most important part of this. So you only talk to your landowner once a year. How do you start the conversation? Well, I think there's some questions that both parties in the relationship can ask themselves. Both parties probably have some thoughts about the environmental health of the farm and the impact of the farm on the surrounding environment. Is there a conservation plan, like Taryn mentioned? A conservation plan, if there isn't one, is a great way to start the conversation. It's free technical advice that is good for 10 years and is very specific to the farm. It has to be current, so they do need to be updated, but only every 10 years. Is it referenced in the lease? If you have a conservation plan, but it isn't part of your leasing relationship, what does that mean? Well, that means that your farmer is not legally obligated to be following that conservation plan in accordance with the leasing relationship. So you need to think about whether or not you want to reference that in your lease. If you don't have a conservation plan, I would seriously consider getting one done for the farm. Another question is, what is holding you back from putting conservation practices on the farm? So I think this question is really going to help folks think through those issues. Is it the term of the lease? Is it the financial insecurities? What's holding you back? And then the most important and most difficult question, how are you going to achieve improved soil health while safeguarding profitability? Clearly, a farm has to be profitable. It's a business. It needs to continue to make money. How are you going to balance these two things? A good lease protects both parties and provides assurance. I will never advocate for a complicated lease with legal words that people don't understand. I think that's a terrible idea. I think leases should be simple. Everyone should understand what's in them, and they should protect both parties. I've been in courts in Maryland where people thought they'd be cute and created nasty leases where the landlord was able to get high late fees and things like that, and the judges threw them right out. The judges don't have any tolerance for that. They are going to want to, if you want an enforceable lease, it has to be an equitable lease. So think about what your conservation and soil health priorities are and put them in there. Put some specifics in there. Reference your conservation plan and also think about, is compliance with the conservation plan going to be a required part of the lease? Don't just reference it. Talk about what happens if someone fails to follow that plan. Alternatively, you could put specific preferences. If you know you want to continue no-till or reduced tillage, if you know you want specific crop rotation, be specific in your lease. And think about whether or not you want the landlord to have a copy of the nutrient management plan. Some folks have that as an element of their lease as well. Consider the consequences of failure. Is it a breach? Do you want to allow a grace period? I think grace periods are pretty typical in leases, and it's a good thing to consider, especially in a farming context. There could be weather situations that are out of the landowner's really, if the landowner's not around, and he comes in. All right, let's have a conversation where you tell the farmer there's been a violation and the farmer has a certain amount of time to cure. If it's not a part of the lease, you're not going to have any grounds to terminate that leasing relationship. Consider the term. The longer the term, the more invested the farmer is going to be in the land. I think leasing, probably more than anything else with agriculture, tends to carry on from the former generation. Well, my dad never had a written lease, so I don't need a written lease. Everything's working fine. We've had the same family, but yeah, it's year to year. You may think it's a constant, but if that family doesn't have a written lease, they may be smart enough to understand that they could be terminated and kicked off of that land. Are they really invested? I don't know. Maybe they are, maybe they aren't. If you give somebody a longer term, they're clearly going to be more invested and treat it more like their own land. What if you can't extend the term? I realize not everyone can extend a term. You may think you need to sell the property in the next couple of years and you don't want to saddle the property with a farmer for a 10-year term. It's not practical for everybody. Consider some legal alternatives. There's some fun, tricky little things us lawyers can do to help people in situations like this. And they're great incentives for both the landowner and the farmer. A right of first offer or a right of first refusal are two fairly typical real estate tools that can be used to give a farmer some assurance that if they're going to be farming property they could one day own. A right of first offer is just a negotiated right to give the holder, in this case the farmer, the first chance to purchase the land when it's ready for sale. The landowner can take it or leave it. The holder typically has a limited right of time to respond. A right of first refusal, that's probably one we've more typically heard of, and that's just going to give the farmer an opportunity to match an offer made on the property. So once an offer is made, then you have to give it to the farmer and allow them to match it. These have to be drafted correctly. I would not recommend anyone try to do this on their own. You need to seek the counsel of an experienced attorney to do this for you. But I would encourage folks to consider it. I do think it's a great way to give a farmer some assurance that they could one day be owning the property they're farming and therefore they're going to take the highest care of it. So what to do if a conservation practice is going to negatively impact yields or profits? Because I think a lot of these have the potential to do that. Consider the form of lease you have. Do you have a cash rent lease? If you do, would you be willing to transition to a cost share or a flex cash lease? That's a way to allocate the risk. If you're both entering into something, you're both going to be potentially, if the landowner is encouraging it, the landowner needs to acknowledge that they're putting the farmer's profitability at risk, and maybe the most equitable thing to do is to change the leasing relationship. A graduated rent schedule is another tool that can be used to address an initial impact to yields or profits. You could discount the rent for a couple of years. If your experts at NRCS tell you this is going to, affect profitability for a 5-year period, then you can write that into the lease. If adjusting rent's not possible, if you say, hey, I need every dollar I get from this rent, I can't lower the rent for this guy, think about what other currency you have. Maybe you could extend the term in lieu of reducing the rent. Maybe to that farmer, getting a lease for a 10-year term has some value because they know they're not at risk then. What if a conservation practice requires an initial investment from the farmer? An important thing is just to allocate the costs in the lease. Consider the initial costs and the long-term maintenance costs. These things need to be maintained when they're spot checked by the conservation professionals. If they are in need of repair, those things are going to obviously be highlighted, and some of those repair costs can be substantial or some of their cost share could be at risk. Consider using a depreciation schedule to encourage a farmer to make an investment. If you put in a simple depreciation schedule, if a farmer has to make an initial investment, they have some assurance that they'll get some money out if the term ends. Troubleshooting in a conservation in a lease. So in working on this project, I've talked to a lot of farmers about this, and the number one issue I hear is when I say conservation practices on leased land, they go, oh, maintenance. Because a lot of times a landowner encourages them, or a landowner goes ahead and applies for the cost share and has them installed and then goes, good news, we have a new conservation practice. Guess who's maintaining it? You. And now nothing else is changing about the leasing relationship. So the farmer sort of smacks himself on the head and goes, oh, great, wonderful news about the conservation practice. Maintenance, I would recommend to folks to really consider what the costs of maintenance are going to be, the labor costs and the actual input costs. If you expect a farmer to assume maintenance for a practice, that's a new part of the lease that should be acknowledged and addressed. Be very specific with the dimensions and the specifications. Buffers tend to shrink over time, and that's the fault of both parties. If a landowner says they want buffers, they should be clear in the lease about what the size of those buffers are, and those should actually be marked on the farm so that the farmer doesn't actually accidentally, I would think in most cases, start shrinking those buffers. Allocate payment for herbicides, weed control, that sort of thing. Agree to meet annually to verify the practices with a walkthrough of the farm. It's a suggestion to maintain communication, also to maintain maintenance responsibilities. Troubleshooting, another thing that we hear about is, okay, so a landowner cares about soil health, they want these conservation practices on the farm. How are they going to actually verify that this is working? How are they going to come? Are they going to come on and take soil samples? Are they going to have the farmer take soil samples and send them the results? If a landowner wants to come on the farm and take soil samples, that's something that should be expressly reserved in the lease. Landowners oftentimes incorrectly assume that because they own the property, they're able to just walk on and do whatever they want throughout the term of the lease. No, not unless it's in the lease. So they need to be specific about their right to do that. The Department of Agriculture does not like to give landowners a farmer's nutrient management plan information or soil samples, so they shouldn't assume they're going to have access to that. And again, reviewing soil test results can be part of that annual conversation between the two parties. Ultimately, the most important thing here is we want to maintain the leasing relationship. I wouldn't want incorporating conservation on a farm to disrupt that relationship. The landowner needs the farmer needs the landowner. Consider leases to be living, breathing things. A lot of times people have the misunderstanding that they sign that lease and that they can't do anything with it until the lease is up. No. You both signed it, you both can amend it, you both can modify it as need be. That's totally fine. You don't even need to go deal with that high-priced lawyer in a lot of situations. You can cross through an initial, it's fine. Both parties need to maintain the communication about the farming and about conservation practices and be willing to adjust practices and lease parameters in order to maintain that relationship. So I think I'm all done, and now we have time for questions.
Okay, so we have 2 walking mics, so we can split the room. Oh, do I just have yours? We have 2 people and 1 mic. All right, so it's just me this time here.
Nevin Dawson, University of Maryland Extension. So you mentioned a couple times about involving a legal professional, and I think that was specific to the right of first refusal. But in general, aside from that, is it safe to say that something is better than nothing and that a legal professional doesn't necessarily have to get involved if you're kind of avoiding those sticky areas?
I would say you should definitely have a lawyer draft your lease. We have a leasing workbook, which is one of our more popular resources, thanks to Paul. However, that is to give folks an idea of the different forms leases can take and to give them an overview of the laws. This is the crux of your farming business. It is worth $500 to go see an attorney and have an attorney draft it. When I was in private practice, it was extremely difficult to defend leases that I had never seen before. Most of the time, when people were in trouble, they came in and they had a lease that was from Staples, LegalZoom, those sorts of things, and oftentimes those were very, very challenging to enforce. So it's worth the money to pay an attorney to draft the lease. If you ever do run into hot water with it, you're going to have a much better chance of having a good result if that attorney drafted it.
Thank you for excellent presentation, both of you. My name is Adel Shir Mohammadi. I am Associate Dean for Research in College of Agriculture and Natural Resources, University of Maryland. My question is, working with actually Chesapeake Bay restoration activities that many of our faculty do both research and extension activities. One of the things, as you all know, in evaluating whether we meet the TMDL goals, both midterm as well as in 2025, is to basically know how much or how many conservation practices we are implementing in the land. One of the things that I have heard the problem is the inspection of the maintenance, as you mentioned, and that is that state, for example, Maryland Department of Agriculture through the MAX program, Maryland Ag Cost Sharing Program, cost shared programs are installed, but they don't have resources to go annually to inspect every one of them to see if that is in place. I'm wondering whether Natural Resource Conservation Service, Taryn, they should actually, besides us paying for the implementation of cost share program, maybe consider some sort of protracted payment for the maintenance of the conservation practices. Otherwise, really, it's like grassed waterways and many of them, they can lose their efficiencies, so therefore, when we want to meet the TMDLs, it doesn't count in terms of efficiency and effectiveness.
Well, I can't speak obviously to the MAX program, and there's certainly folks from MDA that can probably speak to that portion of it. With NRCS and our federal resources, our current policy requires us to do spot checks on anything that's financially assisted annually. So we do spot checks on anything like through our EQIP program. And mentioning EQIP, that's the Environmental Quality Incentives Program. So there's two programs that I'll refer to trying to respond somewhat to your question. Our EQIP program is what we call the Fix-It program. So that is the program that producers can apply for to get practices to treat any kind of given resource concern. A lot of those practices that I showed on the slides earlier, they can get financial assistance to help them to put that on the ground. What we've also done, which speaks more to your question, is that we have now what is called Conservation Stewardship Program. And the Conservation Stewardship Program is more of a rewards program or a maintenance program, which speaks, I think, to your point, I hope, in that producers can come into the field office and for practices that they've put on the ground, that they've maintained in the past, that are providing X amount of conservation benefit, they still meet the standards and specs. And also to the extent that they want to enhance those programs, they can do that through the Conservation Stewardship Program. And that's a whole different financial assistance program. It does speak to the need to maintain the practices, but also to, in some cases, enhance them. So there are some opportunities out there that will help producers with the maintenance aspect of it.
Okay, we have a question back here.
Good morning. My name is Donna Sasser, and I work in St. Mary's County Economic Development. I get a call usually 2 or 3 times a year, either from farmers or new landowners. And as you started your presentation, you said there's not a lot of law in regards to leases. So the scenario normally is somebody purchases the farm recently, and the first thing they do is tell the landowner whether they have a crop on the land or not, you're done. And so that's when I get the phone call. The only thing in law that I've ever been able to find is that a landowner is supposed to give a renter 6 months notice prior to the end of the crop year. Sometimes that helps, and other times we're still just done unless they were to pursue it further legally. Is there anything else?
No, not really, and that's exactly what I was referring to. There's very little guidance in the law for folks on this point. I would be happy to give you a box of our leasing workbooks, and they're also available on our website, because I think they do tend to help people. You can also have them call us. We have a legal info line, and that's on our website, and I think it's on our little slideshow that'll be playing during the break. And we're happy to try to talk with folks and help folks through this process. But yeah, it's a difficult thing for folks to understand, and especially if they're coming into the situation with a residential leasing mindset, where they think, oh, I'll be able to kick this person off in 30 days. You can't kick a farmer off in 30 days. It takes time. However, it's burdensome because a 6-month notice is tricky. So yes, most leases, when they start January 1st, we have a busy time at the initiative July 1st, because that's when a lot of folks are scrambling around to give that notice. But that, I completely agree with you, and those are some of the challenges I was talking about.
The other mic just ran out of batteries. And so this makes it a really good time to take a break. So why don't we thank Taryn and Sarah for a great panel.